Good afternoon.
Good afternoon to the court, Your Honor. Your Honors, I'm Michael Savage of the Overton County Bar, and I represent Ms. Wentworth in this matter. I'd ask to reserve 5 minutes for rebuttal.
5 minutes, yes, sir.
This is a case wherein Ms. Wentworth sued the Turners to try to establish the proper boundary line between their properties and also to eject the Turners for what she believed was her property. The Turners claimed adverse possession in the trial court, and the court ruled that Exhibit 15, the area highlighted in yellow on that exhibit, that they had adversely possessed that pursuant to TCA 282-103 for the required 7-year period. The Turners filed a motion to alter or amend, at which time the trial court amended its judgment, changed that, and decided, well, no, I'm going to say that it was the area of encroachment as shown on Exhibit 13. So basically what we have today, we've got 3 exhibits, and we've got one statute that applies to this, TCA 282-103. The 3 exhibits are Exhibits 13, 14, and 15. Exhibit 13 was an exhibit that was prepared by the Turners surveyor that showed what they called an area of encroachment, and it is in the court file, it is part of the record. On the stand, the Turners surveyor was asked to show, well, what part can you say it shows actual use, actual encroachment? And he drew a yellow line with a magic marker. The court at the end of the trial found that that was the area that they had actually used and basically said that was an adequate defense and dismissed my client's claim. I was not the attorney at the trial. I was only hired for the appeal.
Counsel, what's our standard of review for that determination?
I think it has to be clear and convincing evidence. I think the trial court had to find by clear and convincing evidence. I think this court would have to show that it's clear and convincing evidence and that the judge didn't abuse her discretion at all. So the key here to all this is the 10 Code and 282-103. 282-103 says in the relevant part, Section B, no possession of lands, tenements, or hereditaments shall be deemed to extend beyond the actual possession of an adverse holder until the muniment of title, if any, under which such adverse holder claims such lands is duly recorded. Well, recordation does not apply here. There was nothing recorded. So the issue here is what lands did the defendants actually possess?
Why isn't that line to the fence here? I mean, we have a fence, we have no trespassing signs, and they're claiming to the fence. And why isn't that actual use? They put a fence, they maintained a fence, there's testimony that they were out there regularly maintaining the fence. I mean, I understand this is not perhaps as dramatic of a fence as we had in our last case, but why is this not a to the fence line as actual use?
Well, the problem is, Your Honor, the statute says they have to show what they have actually used. They have not shown even where the actual fence line is. And that's part of our argument today. I'm not going to argue that they didn't have the string up. We call it a string, they call it a horse wire.
Well, I want to ask you about that because when I think of a horse fence, I think of a certain type of fencing. So tell me what kind of fence this was.
Your Honor, as I understand it, Your Honor, again, I was not.
You said just a string.
Well, it was called a string a lot through the trial. Some people were calling it a horse wire. There is a sample of it actually in the record.
Okay.
So that the court can look at that, is my understanding. It's actually in the record.
And a single strand?
It was just a single strand is all
Okay.
it was. And the testimony was, well, ever so often, one person testified, I saw Post-it notes stuck on it. Another person testified, I went down there and it was down a lot of places. Couldn't see it at all. Other places you could see it. There was homemade signs put up on the trees that said no trespassing that were down in some places. You couldn't see them, right? But the statute here is very interesting because the statute says the actual possession. And then the case law goes on to talk about this. The burden of proof is on the individual claiming ownership by the adverse possession. And that proof has to be by clear and convincing evidence. The Mathis versus Campbell case, which we cited in our brief, said very clearly, the doctrine of adverse possession is to be taken strictly and must be made out by clear and positive proof and not by inference or not by inference, every presumption being in favor of the possession and subordination of the title holder. So what happened here in this case, they came to trial, they had Exhibit 13. Exhibit 13 had this area of encroachment on it. He was asked specifically, where did they actually possess? He drew that in. That's what the court found. They filed their application for the court to amend its judgment, and the court changed it to 13 and said, okay, now it's 13, the area designated as area of encroachment. Well, the problem with the area of encroachment is this. The surveyor testified when being asked about that. He said, the area is defined as that I have shown would potentially be an area of transition. I guess you would call it just based on how the property lines lay on the ground. Question. So it's more about comparing it to the lot next door than it is on actually saying that this is an area of encroachment. Yeah, it's more of a line of like symmetry to include the area of encroachment and the area of disturbance. So really just the cleared area around.
Here that he essentially is looking at the area that was upgraded, that was there was more treatment, I guess, there's more debris being removed, more trees being removed. But isn't that actual use? I mean, that's a long-standing way of adversely possessing property, isn't it? I'm out cleaning up the woods in that particular area. That's where, and the next one over is wild wasteland that's undeveloped. And isn't part of his testimony also that all of that was going up to the line he's drawing?
That's not the way I took it, Your Honor. When he made the statement that I have shown would potentially be an area of transition, I guess you would call it just based on the property lines lay on the ground? What do the property lines? I took it that what the surveyor was doing is what surveyors do in boundary line disputes all the time. They have conflicting deeds. They have conflicting evidence. Sometimes they can't make heads or tails out of it. They go out and they put it on base what the best evidence is. That's not what his job was here. His job was to show the area that was adversely possessed. Where this property line with this adjoinder over here is, where this property line over here is for symmetry has nothing to do with this. They have to show actually what they possessed and nothing else. When he says, I'm basing it on how the property lines lay on the ground, that's not what they possessed. He's basing it on something totally, totally different. Now, concerning the situation with the lines on the tree, so that's why we think 13 should not be the court's ruling that the area of encroachment on Exhibit 13 should not be. They tried to introduce an exhibit number 14. 14 was very similar to 13, except for 14 had a very long line, and it was supposedly where the wire fence, or whatever the fence was, where the wire was. It was a really long line, and if you look at Exhibit 14, it's a perfectly straight line. The surveyor was supposed to show where this supposed fence actually was. The testimony that went through all this over and over and over again was how rough the ground was. The ground out there was extremely rough. One person testified there's a lot of brambles and thorn bushes, a lot of fallen trees, a lot of underbrush. It's hard to walk in a straight line. You have to really kind of navigate and try to find your way through. Plaintiff's survey testified it was very rough territory and hard to get into. So what they were telling the court when they tried to introduce Exhibit 14 was, okay, this stream, whatever it was a perfectly straight line for hundreds of feet. How is that possible? It's impossible to do that. So he's done what he did before. He's went out here, he's looked, he said, well, maybe down through here. That's not what the law says. The law says they have to show what they've actually possessed. And on top of that, Exhibit 14 was not produced until the morning of the trial. My client's trial attorney came to trial thinking that we were talking about Exhibit 13 and the area of encroachment. They tried to introduce this into evidence, and the judge rightfully disallowed it. Now, they're going to argue, well, We don't have to have that to show this, but I would argue that they do. They have to show where that fence was. It's not enough just to say, well, there's a fence down through here somewhere, give us the fence. They have to show where the fence was, and they've not done that.
All right, thank you, Mr. Savage.
Thank
We'll
you.
hear from you again on rebuttal. Mr. Fields, good afternoon. The last time I saw you was in the courtroom in Knoxville a year or two ago, if I remember correctly.
About time, just everywhere, aren't
You're on the move.
I? Saw Mr. Caparello in Knoxville 6
He,
weeks ago.
he travels as well.
Good afternoon. I am Doug Fields of the Cumberland County Bar. And if I may, I've done my counter appeal. I'll just kind of like roll all that together, unless you tell me to separate them, and then I'll mumble through both of them. But I can kind of lay it out. I assure you, it will not take me 15 minutes to say what I have to say. There'll be some time for questions, but you just stick them in there anywhere you want to. I strongly believe the Turners established adverse possession up to the fence that they set up in 2001, 2002. They erected a physical barrier when they bought the property. They put up some no trespassing signs. So they supported the line they were trying to claim that they thought was theirs. They patrolled
Counsel,
it.
do we have testimony that establishes where that line is?
I think you do. One, it goes to a post. Mrs. Wentworth testified she followed the line. It was from a post in the back with a yellow top that went to the post in the front, which is actually the Turner's original real corner in the front. So what they did is they went from that corner and they went to a wrong post in the back.
So
And
are these the posts that Ms. Wentworth testified to about string not being attached in places? Is that what we're talking about?
Yes, sir.
Okay.
And she followed it back to the corner, the back corner, and her testimony's in there. You know, in reality, I know my client, Mr. Turner, they pulled out a map and said, is it this point back here or this one? He couldn't pick the right point on the map. Tell you what, I could. I've done a lot of property, and I understand what happened. There's properties laid out behind them, and they went to a corner of a property that's to the rear instead of the corner that was laid out for theirs. I mean, that's what's happened when he thought he found it. Now, whether or not he made the mistake originally or his real estate agent took him to the wrong corner, we'll never know. But he was convinced he went to the right corner. And then once he did that, he made him a fence down there and a border to protect it. And, you know, when people came, he ran them off. When four-wheelers came, he told them, you can't four-wheel here. There was a little shed out there. He tore it down and got rid of it, found a man in a stand, told him, you can't hunt here. To me, that is what you do in adverse possession and exercising dominion and control over a piece of property. You say who comes and goes, and he laid out his boundary, and he patrolled it, and he kept it. And the surveyor says, look, while Ms. Wentworth may have come and took the fence down, I can still find the staple marks where it was nailed into trees. I can still see the spots up there where she pulled the signs down where it's discolored. It's out there, and he, in his straight line, what he testified to in there, I think it's in my replies, is he didn't have enough time to follow it and trace all those down, so he got as far as he could and he projected it out to the end to make an exhibit that we didn't get in. Now, I always wanted that exhibit for trial, but he went and tried to find what we called the area of encroachment in case the fence thing failed. It was a backup, and he figured that's what's going to take longer. So he did that first. He thought he'd come back and shoot that fence pretty quickly, and he got fooling on that.
Is the line for Exhibit 13, the encroachment area, is that consistent with where the expert had seen as area that was upgraded, that was treated differently? And is that boundary consistent with where they had been picking up debris and trees and moving? And is there consistency between those two things?
If I understand your question, I believe so. He's a surveyor. I mean, he said what he said, and we're trying to interpret it. You got to look at all of what he had to say. The way I understood what he did out there was, and let me say this, if you're asking, does that area represent everything that the fence was on, that a fence did? It's not. It's
no,
not.
I'm talking about the area where he had testimony as to there was area that there had been debris picked up, tree branches moved, all of that.
Disturbed, improved,
and
words
disturbed,
like
improved.
that.
Is that the line that we're looking at in Exhibit 13? It's that line?
It is.
Okay.
And what he's done around there, and in my humble opinion, he's had his, I think what he's saying is to find the area that they physically encroached on. I went out there and I looked to see where the property started to change. And you know, the Turners own 40 more acres over here, so they didn't cut wood off from what they encroached on. It was just all the same to them. But closer to their home, they did more clearing. And there becomes a point where what they did begins to fade into the property that just doesn't look very much improved anymore. And that's the line he's trying to follow. But the fact of the matter is, might have cut a tree and done some brush in an area like this and not done much over here and then done something over there. And I think what he's testifying to is when I went through there, I kind of didn't think anybody would make a boundary like this around a piece of property. So I kind of tried to fairly work that together and make a boundary around it where it looks like they've been and worked and improved on things, but make it so it wasn't crazy and give it some symmetry. I think that's what he's trying to explain, and that's my best explanation for that, because he does use the words about disturbed, improved, changes, but he also uses the symmetry language in the things they talk about. So that's my understanding of and what I think he was trying to explain when we asked, well, can you show what we had improved, and then can you shoot the line for us? And that's the two things we wanted from our surveyor. We didn't get all of that because it just come in a little bit late. And you know, he testified part of the problem was, well, and as Miss Wentworth admitted, she went out there and pulled it down. Went down there and pulled it down, and so we didn't have it to go by. So she kind of eliminated that evidence for us, and don't think there ought to be a lot of benefit from that. But you'd ask questions about the horse fence, and you may go back and look at it. You know, there's wood horse fences and there's woven wire fences. This type of wire that he used was cheap. It's the electric horse fence. It's got a metal wire through it, and it's got a plastic wrap and covering over it that's kind of flat in two different colors, so the horse can see it. It makes it stand out to the horse with the enhancement over the metal, and that's what he put across there. I would think if it makes it more visible to horses, it makes it more visible to people. Seems to me that they didn't have any trouble finding it when they got on their property, because Miss Wentworth's son walked out there, came to the fence, seen the signs, and followed it out. Didn't cross it, took it for what it said, no trespassing, reported to his mom. I think somebody's taking part of your property. That's exactly what they thought. Isn't that the whole point of putting up some kind of barrier or marker to let the true owner know that I think I own over here? He was mistaken, but it served its purpose. When they got there, when they ever got on their property and looked, they knew what was going on. Somebody had laid claim to part of their property. And I think that's exactly what adverse possession's all about. And do I wish I had the big green fence that the guys before me had? I do. All right, but that's not the fence he put up. He said it was effective for letting the hunters and people know his boundaries and stay off his property. And it was effective to let the Wentworths know somebody thought they owned part of their property.
Was part of this fence down before Ms. Wentworth started to remove the fence? Part of it, as I recall, some of her testimonies, the fence was down in certain places, was it not?
Miss Wentworth says it was down. Her son, he might have said it was down. They don't elaborate on that. Let me say respectfully too. I've got a farm. I got a 120-acre farm. I got a single wire steel electric fence around the border. I figure people know when they get to that, that's Doug Fields' farm. And when you step over that, you're coming on the mine. Does it get down sometimes? Yeah, you have storms like yesterday. Branch fall on it, it's down. You know, and you can still see it. You can see where it goes, but it's down. I got to go cut that off and fix it. Turner said, yeah, there'd be storms and things, and they come by every year right before hunting season, which is important to them to keep the hunters off, and go back and fix that. I don't know that when I fence off my property that I need to fix it weekly. It needs to be sufficient that somebody can recognize that it's some kind of marking. And You know, I think she exaggerates on the down. I believe it's not at all impossible. They didn't have some branches on it when they came out there in January. Hunting season starts, back in November? You have some pretty stormy, windy weather in November and December, and by the time they're out there in January, it very well may be that there was some branches on it and it was laid to the ground or pushed to the ground. But I don't think it was tore apart. Of course, on my farm, I got a bear that's twice come through my steel fence and popped it in two and stretched it out across the field, but you can still tell where my boundary line is. And
If there's an area between the upgrading disturbed area
yes,
and the fence, is the fence itself, given the nature of this fence, is that an actual use of the property to put up a fence? And there's some gap between these 2 points, right? And the expert witness says, you know, it doesn't go all the way to the fence, the disturbed area. Are you actually using the property between the line of where it's disturbed and where the fence is? If you just put up the fence further out beyond what you're actually clearing and moving, and where you've got the mowing and the pond and all of, and it seems to me there's a lot of classic adverse possession activity going on there. But what about that gap area? Is that really actually being used?
well, I think the standard is, in those cases, to put the use in the land to the use that it's fit for. And from all I can tell about this property, it's fit for hunting and deer and growing trees. So we clean the underbrush, we burn dead trees, we leave mature trees. The surveyor says on our side, a lot of underbrush was gone, he saw mature trees. So is growing trees not a purpose? And we have it green belted as forestry ground, and you cut them every 20, 30 years. But I understand how do you distinguish that use from theirs, but I mean, that's the use of the
Did your client have a burden to establish exactly, if you're going to claim to the fence, did your client have a burden to show exactly where that fence was in this case?
I think that there needs to be evidence in there where you could understand what he was claiming. I think that's fair. And I think, respectfully, that proof is in the record. That it went from corner to corner. His son said it went to a corner. Ms. Wentworth found it in a corner that's marked with a yellow top. We got a picture in there of that fence post with the yellow top. Surveyor said he had seen it. It ran pretty straight through the woods out there to that corner. I think this, she took down part of the fence. Fence might have moved in a little bit this way and give her more ground. It might have moved a little bit that way and took a little more away from her. But she took it down so we can't tell. But my experience with damages is when you've established that you have something and then you can't get it exact, then you get as close as you reasonably can. Here, I think you can get very reasonably close to what the Turners had always marked and claimed, by the marks on the trees, by the location of the post that's been identified, by the things that are on the sign. I think you can get back, and I think that's fair because Ms. Wentworth took away the very marker during litigation that showed us exactly what part of the field he claimed and where his line was. And you know, we didn't bing her on that, but I think it's significant that you want to argue that you don't have an exact location of the fence when the plaintiff went and tore the fence down and left you to find it the best way you can. But I do think there's evidence in there that gives you a reasonable understanding of what we claimed and what they had always thought was theirs. Told you I wouldn't talk for 15 minutes. You all have any more questions?
Hearing none, thank you, Mr. Fields.
Thank you very much.
Mr. Savage, your rebuttal.
If the court at some point could look at page 22 of the trial transcript, they were asking Ms. Wentworth when she first found out about that a home had been built on the property, and she stayed at line 24 on January 4th. I got a text from my son that said there's a problem with the property, meaning the property in Fentress County. In appellee's brief, they stated that Ms. Wentworth took the fence down on April the 9th of 2022, and for that proposition, they cited page 24, line 25, where she said, well, it was April 9th because it was the day that we went to look at the home and I was meeting a forestry guy out there. That was April the 9th of 2021. They're trying to make it look like that Ms. Wentworth went out there and took this down right before trial so they couldn't get out there and do what they needed to do. Exhibit number 13, if my memory is correct, was prepared by the surveyor on February the 12th of 2022. Exhibit 14, which is what they tried to use to show where this fence was prepared on June the 9th of 2022, which was 1 day before the trial. So what they're asking this court to say is, well, you should blame Ms. Wentworth because we didn't have sufficient proof to show where this fence actually is. All they had to do was ask for a continuance. If he went out there, Judge, I can't find it, ask for a continuance. But that doesn't make any sense either, because on his Exhibit 14, he says this is a straight line. It's a perfectly straight line for hundreds of feet. Well, if it was a perfectly straight line, all he had to do was find the first 3 points, the corner point, the next point, and the next point, and I believe if I had been a surveyor, I would have known to start looking in a straight line. So the fact that they say they couldn't get this until the day before the trial because of something Ms. Wentworth did, it's just not credible. It's not credible at all. But then they even he admitted, well, it started here and it went back here. Well, maybe she lost a little here, maybe she lost a little there. It went back and forth and he straightened it out. The statute says they have to show what they actually possessed. Not close to what they possessed, not about what they possessed. They have to show what they possessed. My predecessor went to trial that morning thinking that he was arguing about Exhibit 13, where it talked about the area of encroachment. Next thing he knows, and he objects, we're talking about a big long line that runs way down in the woods. And to answer Your Honor's question, there's a lot of land back here. We're not talking about 50 feet, 100 feet. From the area that the actual encroachment was supposedly shown on 15, where he actually drew it in, we're talking about way, way back, all the way back to the line. One of the defendant's sons testified that he would go back every year and have to help them put the string back up because it would fall in the wintertime. So to say that this was there, and it was there so that somebody's going to see it every time they go out there, it's not what happened. It's not what happened. We had one string, one wire going through the woods, heavy woods, hard to get through. And these people, my client was supposed to see that when it was down a good portion of the time. So they haven't proved what they actually possessed. I guess to be totally honest with the court, they probably proved they possessed the house because the house is a fixed object and it's there. We know where the house is. They've lived in the house. I think they used the road going into the house. But as far as anything else, have they proven anything or shown where it is? No, they haven't.
Thank you, Mr. Savage and Mr. Fields, for your arguments. We'll take your case under advisement. That concludes the docket.